going to go ahead and call the, we're getting a little feedback, and I think it's me. Are we still getting the feedback? It's my speakers. How's that? Okay. Sorry about that. Trying to figure out the technology and what causes the issues. I'm going to go ahead and call the Transportation and Public Safety budget meeting to order. Thank you, everybody, for being here. This is a little bit out of order. It's not on the agenda, but I know we had one member that had some concerns. Everybody should have got an email from us about what the new procedure is for you guys signing our budget report outs to appropriations. You know, historically, everybody signs what we did in committee to say that's what actually happened. They're trying to minimize some potential exposure to COVID for both staff and us. So they've made an assumption that you consent unless you contact them, that you don't consent with the report, and they're going to email it to you in advance. And Representative, and there is a feeling among some representatives that it should be not an automatic opt-in, it should be an automatic opt-out. And I was wondering if Chris or Aaron would want to respond to that concern. Aaron?
Can you hear me?
Yeah, go ahead.
I can totally concur with what you say, Mr. Chairman, in the sense that this is just a signature sheet saying you were there and these are the actions that were taken by the committee.
Yeah, and Aaron, do you know who made the decision that it would be an opt-in instead of an that the positive action would have to be an opt-out rather than an opt-in?
Not sure who exactly.
Could you just check and then have them, how many of you have that concern? Representative Delperdang and Representative Esau have those concerns. If you could have someone contact them and just see whatever we can do to make everything work as well as possible. Okay?
Certainly.
Okay. So with that, are there any bill introductions? Seeing none, we'll move on to the next item on the agenda. And we have with us today Heather Cessna with the Board of Indigent Services. They've got, just for history, there's historically been some staffing issues at this organization and some caseload issues, and she's here to talk to us about a long-term solution that her organization has worked on to address these. Go ahead, Heather.
Thank you very much, Chair and committee members, for letting me come in and talk to you today. I do fully anticipate that we're obviously going to have a more in-depth conversation about our specific budget request coming, within the next few weeks when it's our turn to come up before you. But I did want to provide some historical information and a little bit of background information, because particularly if you're not familiar with the public defense system in Kansas, or if you haven't been on this committee before, there's some history there that I think is going to be important to the context of the conversation that we have. And this is really born out of a conversation that started last year in front of this committee. We were before this committee with some unusual budget requests at the time, and there was a discussion basically that there had been in previous years attempts to essentially band-aid some of the staffing issues that we had. And as a result of the conversation out of this committee, there was language inserted into our budget bill that required us to come back with a staffing report to the Legislative Budget Committee last fall on our staffing issues, and with a proposal that essentially would attempt to no longer band-aid things, but come up with a full-fledged solution to all of our problems. And so The report that we created was submitted to the Budget Committee last fall. I submitted that to your committee assistant, so hopefully you've had a chance to at least see where that's at. And you can read it, it's pretty extensive. But what I'm going to go through today is to kind of summarize some of the key points from that and give you guys an opportunity to ask any questions, because I know it's a lot of information to kind of get all at once. So I do appreciate you letting me come and visit. Today, really what I'm here to talk to you about are the issues that the Board of Indigent Defense has been facing. Those include high caseloads, a lack of pay parity and other compensation issues, and a lack of sufficient staffing and other basic infrastructure and resources. And these problems have all been particularly exacerbated by COVID-19 this year. In short, our public defense system really is at a breaking point. If you haven't had the experience of being involved in our criminal legal system in Kansas, then you may not understand why BIDS is a crucial linchpin in our state courts. First of all, obviously, if you're charged with a crime, then you have the constitutional right to assistance of counsel under the Sixth Amendment. That's pretty basic. I think most everybody knows that. But obviously, what you may not realize is that the state of Kansas provides for the constitutional right of counsel to all Kansans through our board, which is the Board of Indigent Defense Services. And what you may not know is that 85% of adult felony cases in Kansas require appointed counsel. And in order to give you some more context to that, 65 to 70% of our court dockets in Kansas are criminal cases, and 85% of those require appointed counsel. And this is why BIDS's problems are not just BIDS's problems. They really have a huge impact on our criminal legal system as a whole. We here at the Board of Indigent Defense Services provides all of those adult felony appointed counsel in every court of those 85% that qualify through either our public defender program or through our assigned counsel program. And here's just some basic information about our public defenders, in case you're not familiar sort of with how this works. Our public defenders and public defense staff are state employees who are hired by their chief public defenders in their individual regional offices. And as direct employees of the agency, they're subject to the direct supervision of their chief defenders and the oversight of the board. There is only 123.5 public defenders in Kansas. That is compared to 355 criminal prosecutors throughout the state of Kansas. We have 11 trial offices. There's also one appellate office, one trial death penalty office, 2 capital appellate offices, and 1 capital habeas office. So there's not that many compared to the number of prosecutors in the state. Our assigned counsel program, however, it works differently. Our assigned counsel are generally private attorneys who volunteer to serve on the panels at the district court and agree to accept low-paying appointments or contracts to handle criminal cases. And for the most part, they are typically small firms or solo practitioners. As private lawyers taking cases, they are not subject to the direct supervision of the board. Instead, we approve their experts and ultimately pay their claims after they submit their vouchers. But we really have little control over the quality of representation along the way. In judicial districts where we have a public defender's office, assigned counsel serve as backup to that office in case we have a conflict or we have to stop taking cases because of caseloads. But in areas where we don't have a public defender's office, the assigned counsel program is the main delivery system for our public defense services. We have around 350 assigned counsel throughout the state of Kansas. So here's the breakdown for this last year, and these numbers are a little bit off from what we normally would see, in part because of the kind of slowdown in cases that happened right at the end of fiscal year 2020 due to COVID. But in 2020, we handled just over 26,000 cases. 44% of those were handled by public defender's offices, and 56% were handled by our assigned counsel program. Consistently, public defenders are more economical than our assigned counsel. In fiscal year 2020, our assigned counsel cost $175 more per case than if a public defender had handled the same case. And that's partially just because of the economy of scale when you're operating a large public defender's office versus a solo practitioner. Typically, when once a case is charged, the person will apply for cancel, and if they cannot afford to hire their own attorney, the judge will look at their assets and determine whether they qualify for counsel. The judge will then assign them an attorney. And if there is a public defender who is available, the judge will typically assign that public defender. If there are not public defenders available, then the case is usually assigned to the assigned counsel. And there's a variety of reasons why the public defender would not be available. Either we don't have an office in that particular area, or the public defender has like a conflict on a case and is not able to take like a co-defendant, or we oftentimes have to refuse cases because of high caseloads. And that ultimately is one of the big problems that we've had lately, is that we have increasingly had to refuse cases in our public defender's offices because we just simply don't have the support staff to be able to staff those cases appropriately. And so we've had to stop taking cases temporarily and put those back onto the assigned counsel program, where normally those are cases that our public defenders would have taken if they had the sufficient staffing. Public defense attorneys, both public defenders and the assigned counsel, handle everything from low-level felonies and drug crimes all the way up to high-level off-grid crimes, sex crimes, and capital cases. The problem is that the lack of resources that we have, the public defenders, lack of assigned counsel, lack of financial resources and infrastructure resources have left us unable to effectively and cost efficiently handle all the cases that are coming into our system. And so that's kind of one of the first things that I want to talk about is our caseloads. And that is one of our most immediate problems. 50-year-old national standards basically put an absolute maximum caseload cap at no more than 150 felonies per year per attorney. And the high caseloads, the reason for that is because high caseloads deter people from becoming public defenders or joining our assigned counsel appointments lists. They also drive our mission-driven employees away from our agency. One of the things that I found most concerning was when we conducted, as part of our process of identifying what our issues were with our staffing problems, we conducted a employee survey last year and determined that while 81% of our employees that answered our employee survey reported that they came to work for our agency because they believed in the work we do, so they were mission-driven employees, 55% of them had reported that they had considered leaving their public defender offices within the last year, specifically because of caseload issues and compensation problems. So that's highly upsetting. High caseloads are also an effectiveness issue. Obviously, when you have too many cases, you simply don't have enough hours in the day to do all the things you need to do to represent those clients effectively. And that's also why high caseloads are an ethical issue. The Kansas Rules of Professional Conduct 1.3 Rule on Diligence explicitly says that a lawyer's workload should be controlled so that each matter can be handled adequately. When attorneys can't handle their cases effectively because of high caseloads, that causes a number of down-the-line problems, including viable claims of ineffective assistance of counsel, wrongful conviction lawsuits, legal malpractice claims, ethics investigations, and the potential for protracted and expensive litigation over the constitutional adequacy of the Kansas public defense system as a whole. And of course, most importantly, high caseloads impede our ability to provide our core agency mission, which is to provide a zealous and effective criminal defense to our clients. So let's talk about caseloads. I've included in this presentation a breakdown of what our fiscal year 2020 trial public defender caseloads look like, based on an averaging out their caseloads by the number of attorneys they have by the number of cases they were handling. In fiscal year 2020, only 3 of our 11 trial public defender offices were able to come in just at or under the 150 felony absolute maximum caseload cap. However, even those that were able to do that had to pay a price to do so. For example, you'll see at the top of that list is our 3rd Judicial District Public Defender here in Topeka. They were right at our 150 felony caseload per attorney for fiscal year 2020, but in order to not exceed that, they had to close their office to new cases for 172 days in fiscal year 2020. So the only reason why they were able to meet that 150 year threshold and not go above it was because they refused cases for 47% of the fiscal year. So obviously you can, it doesn't take a lot to figure out that when you're refusing cases for that long, all those cases are going off to our assigned counsel program at $175 more per case. It's just not a very economical use of our resources. You can contrast that with our main public defender's office in Sedgwick County, which had our highest average caseload among the child public defender offices at 278 cases per attorney per year. That office only refused cases for 55 days in fiscal year 2020, or 15% of the year. However, that office also, unsurprisingly, had the most chronic turnover problems of all of our trial offices in fiscal year 2020, in part because of the high caseloads. On average, our trial public defenders were carrying approximately 205 cases per attorney per year in fiscal year 2020, or 55 cases above the absolute maximum national standards. So then the question for you is, what does that actually mean when we say that somebody's carrying 205 cases on average? Well, what that breaks down to is that that attorney only has approximately 10 hours per year per case to work on those 205 cases. For perspective, a recent study of the Louisiana public defender caseloads found that a lawyer needed to spend approximately 22 hours working on low-level felony cases for reasonably effective assistance of counsel. That same study found that a lawyer should spend approximately 200 hours on a felony case carrying a sentence of life without parole. Our public defenders are currently averaging 10 hours per case per year on everything from low-level felonies up to off-grid life sentences. The thing that you have to remember about our situation is that we don't have any control over how many cases come into our system. I mean, it's not like the Department of Transportation where if we don't have the money, we can just not build a road this year and put it off till next year. We have a certain number of cases that come in, and those have to go somewhere. Our caseloads are basically controlled by the legislature, who decides what to criminalize and what crimes to make felonies, and the prosecutors who exercise prosecutorial discretion over what cases to charge, what cases to divert, and what charges to include in any given case. So, what happens when our public defenders can't accept more cases because they don't have the sufficient staffing? Well, those cases then go to our assigned counsel program. Right now, BIDS is paying our assigned counsel at the statutory rate of $80 per hour. A 2017 KBA study determined that the average per hour rate of private counsel in Kansas was approximately $225 per hour. That means that our $80 per hour rate is approximately 64% below the average going market rate for private counsel in Kansas. The problem with that low hourly rate is that it results in difficulty recruiting assigned counsel, both the number of assigned counsel on our panels, but also it makes it difficult to recruit experienced counsel to handle those high-level cases because we're just not paying them enough. It also incentivizes private counsel to take higher caseloads than they probably should in order to cover their overhead costs and make ends meet. And it has also been statistically proven to show that it incentivizes private counsel to go to trial less often because the low rate of pay means that pleas are actually paid better for the time spent on them than jury trials are. Unfortunately, those pay issues are not unique to our private assigned counsel. In spite of national standards that call for parity of resources between prosecutors and public defenders, our public defenders are consistently paid significantly less than their prosecutor counterparts with comparable experience. So while starting salaries for prosecutors and public defenders may start out roughly comparable, basically what happens is as soon as you have any amount of experience, the ability to get paid more at the prosecutor's office so far outpaces what the public defenders can afford to pay you that we see a lot of our public defenders leave to go work essentially across the aisle doing very similar comparable work, but for the prosecutor's offices. A recent review of prosecutor salaries in Kansas determined that when comparing our top paid public defenders in several cities where there were comparable prosecutors' offices, the top paid prosecutors were paid anywhere from 23% to 50% more than our top paid public defenders. And that parity issue isn't limited just to prosecutors and public defenders. It also extends to other comparable government salaries. For example, are top paid public defenders in the agency with 25 to 35 years of defense experience, and each as head supervisors of their individual offices, make a salary comparable to what an assistant federal defender with 0 to 3 years of experience could make one block down the street from our public defender office here in Topeka. It really is no wonder that we have both a recruitment and a retention issue in our agency. If the caseloads were not enough to deter people from working for us, our compensation issues surely are. These problems would be bad enough, but to add insult to injury, our agency is also severely under-resourced. We lack sufficient staffing in our public defender's offices. We lack sufficient support staff in our administrative office. We actually administer our entire agency with only 8 full-time employees, which is not enough to hardly keep our accounting processes going for our massive assigned counsel program. We also have no formal training division to provide the necessary ongoing training to our 200 employees and our 350 plus assigned counsel. That's pretty unusual for most public defender systems in the nation. We lack basic infrastructure, frequently struggling to afford servers, phone equipment, computer equipment, and legal resources. We still operate our assigned counsel program on a paper voucher system and do not have a modern case management system, all due to a lack of funding to support those items. And of course, the impact of COVID with the sudden need to remote work and appear for court remotely and interact with our clients remotely has only exacerbated those issues of resources. Now, we were asked by the committee last year to look at our agency issues and attempt to create a fundamental solution to these problems. And these are big problems. But we were asked to stop band-aiding that. And so what we did was we sit down and we looked at realistically, what is this going to take? We did an extensive study of our caseload issues and calculated out based on these national standards what it would take to, how many new attorneys and support staff it would take to handle those cases. And ultimately our staffing report and our 3-phase plan in that report to fix our public defense system is what we ended up coming up with. To solve these problems, really fundamentally, the issue that we need is that we need a commitment from our partners in the legal system, our prosecutors, our judges, the governor, and the legislature, to commit to investing in our system, because ultimately investing in our system has a variety of benefits. Public defense attorneys, private attorneys, paid on a case-by-case basis, while always a necessary part of our system, really get little to no supervision, whereas bids primarily fits the bill for those cases once they're done with a minor ability to control those costs or the quality of representation along the way. So investing in public defender offices as our main public defense delivery system creates a structure that can help our defense attorneys meet their ethical obligations and also ensure that they're following best practices in a way that's more cost effective for the money that we're spending on it. Public defenders have the necessary independence to make decisions about their client's representation, independent from pressure from the court. They are subject to substantially more oversight as the staff are supervised for quality representation by the board itself and their chief public defenders. Attorneys are not paid by the case, so they're not incentivized to take more than they can reasonably and effectively handle. Attorneys and support staff work together on a team of cases, which not only provides better outcomes, but also uses an economy of scale that makes public defenders more cost effective in general. Staff can be trained and mentored in-house, which provides for more continuity of service throughout our state legal system. And public defenders' offices also act as a single point of contact with their jurisdiction, comparable to a prosecutor's office, in order to address those larger justice system issues with better coordination, which actually has been quite a big issue lately with all the issues with COVID. We've had to use our public defender offices to kind of take on that role for both our public defenders and our assigned counsel because they're just institutionally better positioned for that. Also, public defender's offices, especially if they're consistently well-staffed, can be consistently available to the court, alleviating much of the court administration's headaches of locating appropriate counsel in each case. And research has shown that public defenders get better outcomes than individual private assigned counsel, usually including reduced case time from fewer continuances, reduced likelihood of convictions, reduced likelihood of prisons, reduced sentence length, and reduced potential prison costs. So the question we asked was how can we do that better here in Kansas? And we believe that can be done through the sufficient staffing of our basic needs and then through a move towards a more holistic defense practice. Now, I'm guessing probably this is the first time you've heard the term holistic defense. And so I kind of wanted to give you just a little bit of information about that. And this is not something that we're obviously going to be ready to jump into, 2 feet forward until we've got the foundations of our system fixed. But holistic defense is an aggressive legal advocacy that basically recognizes that most poor people who are charged with crimes are struggling with a myriad of other issues beyond just their criminal case, and that then affects their ability to get an appropriate outcome in their case and to avoid additional legal contacts with our system. And so holistic defense has been a proven way to cost effectively meet our clients where they are in a way that provides significant benefits to our legal system and does not endanger public safety. And this is one of the things that I wanted to talk to you a little bit about today. A recent 10-year study by the RAND Corporation and the University of Pennsylvania School of Law did a study of holistic defense programs in the Bronx and found after a 10-year study that the holistic defense practices there were able to prevent more than 1 million days of incarceration. They were able to reduce the likelihood of a prison sentence by 16%. They were able to reduce the actual prison sentence lengths by 24%. And they were able to save taxpayers an estimated $160 million in inmate housing costs. And that's all in spite of the fact that higher pre- and post-trial release rates, they were able to also prove that those release rates 10 years after case resolution resulted in no more crime than those people who were incarcerated for longer periods of time and did not receive holistic defense. So in other words, holistic defense has been statistically proven to significantly reduce incarceration and save taxpayer dollars without harming public safety. That's one of the reasons why public defense systems from New York to Kentucky to Texas have all embraced that model in their public defense systems to varying degrees, because it saves taxpayer money and it uses resources more wisely. We think Kansas can and should do that too. I'll go through and just kind of detail briefly what our current year budget requests are. And like I said, I know we're going to get into that in much more detail later on, but just so you have a preview. In order to address our most dire and immediate problems with caseloads, staffing, and pay issues, as well as to begin that transition to a client-centered holistic defense model, we did make several necessary and fundamental budget requests for fiscal year 2022. Those budget requests are the first phase in our 3-phase plan to transition to a holistic defense model and to solve these problems sort of once and for all. Those budget requests include $7.9 million for staff adjustments to address our ethically concerning caseloads, including 26 new public defender positions, 15 additional legal assistants, 35 additional investigators, and 13 additional administrative assistants, as well as 6 additional administrative staff. It includes $4 million for attorney and support staff pay parity compensation adjustments based on those comparisons with similarly situated prosecutors and other government employees. It includes $164,000 for the establishment of a BIDS training division and the associated costs with that. It also includes $3.5 million for an increase in our statutory rate from $80 to $100 an hour as the first phase in a 3-phase plan to increase our assigned counsel rate in order to maintain robust assigned counsel program. And also it includes around $350,000 for basic immediate infrastructure needs, including IT security items and a modern case management system. But we also understand that if we're going to ask for that kind of investment, obviously we need to be able to report back on the progress that we make and the impact that that investment has, not just on our agency specifically, but also on the criminal legal system as a whole. And so as a result of that, we've identified a variety of measurements that we think we can look at and regularly report on to the legislature so that you can better monitor the impact of this investment. These measurements are intended to address a number of issues, including cost savings, but also are intended to look at some of those quality of representation issues that ultimately lead down the line to issues of ineffective assistance of counsel and wrongful convictions and things of that nature that require additional legal resources later on, and so that we can better assess those. Some of these success metrics will show some immediate improvement. Some, however, will require longer study to fully grasp the impacts of the investment. But that's okay, because in order to address these issues in a fundamental way, we're going to have to play the long game here, with the goal that in 5, 10, or 15 years, we will eventually be able to have a substantially improved, sufficiently resourced, and constitutionally acceptable quality public defense system in Kansas that offers substantial benefits to the entire criminal justice system. So, in short, our goal is to shore up the crumbling foundations of our public defense system and eventually move towards that more holistic defense model in a way that we can reduce the amount of cases that our public defenders are refusing due to caseload overload and employee turnover, so that we can reduce the reliance on our assigned counsel program in areas where we have public defenders' offices, so that we're not overloading our panels, so that we can provide better quality service to our clients through better resourced, less overworked public defenders and assigned counsel, and so that we can produce better overall outcomes for our clients and for the criminal legal system by intervening with clients earlier and in more depth, so that when we get the case outcomes that are appropriate for them, they can also continue to avoid future legal system contacts. And then also so that we can reduce the overall cost of the legal system by working cases more efficiently and effectively and catching those errors like ineffective assistance of counsel claims and wrongful conviction claims early, and saving taxpayers money through the overall effective use of our resources. So the chronic underfunding of our system is not just a bids problem. It is a criminal legal system problem. And everyone, defense counsel, defense clients, prosecutors, victims, police, and the courts all suffer the expensive consequences of it. That's why the fact that I mentioned at the beginning of the presentation that 85% of our adult felony criminal cases in Kansas require appointed counsel matters, because our entire criminal legal system really hinges on public defense being appropriately funded and resourced in order to function well. And right now it's not functioning. So starting with our budget request that we've made this year and looking forward into the future with our 3-phase plan, we intend to correct those issues. But to do so, we need the commitment from all of you, including the other stakeholders in our system, to support our efforts to sufficiently staff our caseloads, to make our inroads in recruiting and retaining our employees, and providing appropriate support for both our public defenders and our assigned counsel. I know that was a lot of information to throw at you all at once, and I suspect you probably have questions. So I am more than happy to answer those at this time.
Committee members, anybody have any questions? Go ahead, Representative Depperdang.
Thank you, Mr. Chairman. Appreciate you coming to go through this. I do have a couple questions. First one, it was early in, it was where you're talking about how the bids works, but what constitutes indigency? I know the definition of it, but is there a certain threshold dollar-wise or so?
Yeah, we have, our thresholds are tied to the federal poverty levels, and every year we change those with the federal poverty levels, and they're included on the application that we have on our website that everybody has to fill out in order to get assigned counsel. So they have to fill out information about all of their assets and resources before they can even get the judge to determine that they're indigent.
So it's not based on how much you make, it's what you have, or?
It's a combination of that.
Okay, so again, I don't have a clear answer on that. When you got into what it means, it was talking about the average case, 205 cases per year per attorney based on 40 hours. Is being an attorney, and I don't know if you are one or not, but
I am.
is that a 40-hour-a-week job?
Well, and this is one of the things that we, I think, have to address as a profession. And this is actually, I'm separately, apart from this position, I've been on the Kansas Supreme Court's Attorney Wellbeing Task Force. And the issue with treating lawyers like they are expected to work 80 or 60 hours a week every week is that you burn out that profession. It leads to high rates of alcoholism and burnout and ethics issues and all kinds of stuff. So I think it is important for us to treat these positions. I mean, there's always going to be times when, obviously, if you have a trial coming up or something like that, where you're going to end up working in evenings and weekends to get prepared. But we shouldn't create our case assignments or caseloads based on the assumption that you have to work 60 or 80 hours a week in order to get your work done, because I think that's mistreating our employees and causing them to leave.
May I continue? Okay. The pay parity, you hit on that, and that was some good stuff. But again, with pay parity, I kept looking, I kept waiting for it. It never came up. It's an unknown amount. I make $88 a day. Is that what they're making?
Our starting salary for our public defenders is $55,683. There is no one in our agency that is paid more than $105,000 a year, and that includes our most experienced public defenders. So the problem that we have, like I said, is that $55,683 may be an appropriate starting salary when compared to prosecutors, but once you get into having 5 or 10 years of experience, frequently our public defenders are still sitting at $55,683 or $60,000 a year, whereas their comparable prosecutors who are, working the same cases just on the other side of the aisle are closer to $75,000 or $80,000 a year, depending on the individual area. Obviously, they're, Johnson County probably pays their prosecutors a little bit better than, someplace out west. But that's what we found. We're trying to look at areas specifically where we had our comparable public defenders' offices to look at where their prosecutors were to try to give us a better comparison there.
And is there a number you could put to us as far as a turnover rate within your, I'm going to say your office due to a lack of term, but?
Yes. We were as high, within the last 2 years, we were as high as a turnover rate of 1 in 4 public defenders leaving. This last year, we were down to about 15%. And the problem that we have is that we're still losing those incredibly experienced public defenders as part of that turnover rate, which then costs us money because it takes us a good year or two to get a new person in up to speed. And so that's a huge cost to our agency when we're losing those experienced attorneys.
Okay, thank you. And no more questions. I appreciate it.
And I don't mean to interrupt. I can get back with you and show you the indigency stuff so that makes more sense to you in answer to your question.
Representative Resman.
Heather, can we go back to the page that has the 2022 budget requests?
The page that has the 2022 budget request.
You mentioned how many attorneys that you needed to hire. I couldn't write fast enough, so that's my.
Oh, you're fine. I'll go back and look just to make sure I don't have that off. For this particular budget request, that was 25 new attorneys for this year. Now, you'll notice if you look at our budget report, as part of that staffing, that the staffing requests for future phases continue to increase. And part of the reason for that is because the, sorry, I'm trying to talk while I'm going back in my presentation here to find that information. Part of that is because the 2020 numbers for our caseloads were actually a little bit decreased because of COVID. Not because those cases are not necessarily there, but just because things like slowed down and cases were just not moving because of the court shutdowns. So what we did was our phase 1 staffing report, which is what the basis for our fiscal year 2022 request was, included, 26 public defenders positions, 15 additional legal assistants, 26 public defenders, 15 additional legal assistants or paralegals, 35 additional investigators, and 13 additional administrative assistants, as well as 6 additional administrative staff. And that was based on looking at our caseloads for the number of public defenders that we would need in order to get below that 150 threshold for each of our trial public defender offices, and then using the National Association for Public Defense recommendations on the staffing ratios for our support staff, like our paralegals and our investigators and support staff, to figure out then from there how much we have versus how much we need in order to get up to those ratios.
So the 26 and the 123 would take you to 149 attorneys. Is that the minimum you need, or is that would be adequately staffed?
That would be the minimum that we need based on the 2020 numbers. In phase 2 of our report, we did projections for what we would need for additional attorneys based on a more normal set of caseloads, which would be from 2019. We use that as like a regular year because that was a non-COVID affected fiscal year. And based on that, we were going to need potentially, and I will get the number so that I don't misquote myself. In order to get that, we were looking at closer to 80 additional attorneys in order to get below that 150. And that's because our caseloads were significantly off from COVID. So, and that's based on that 150 threshold.
So all of these numbers are the minimum. After she looks at it. I have another question, but she's looking something up right now.
Well, you can ask while I'm talking.
The infrastructure requests, what is that?
The infrastructure request includes, we had a number of IT security issues that came up during an LPA audit that we actually got money from the legislature last year to address, but then that money was removed because of COVID right at the beginning of the year. It was lapsed back in their efforts to try to balance the budget in light of the fiscal issues that we were having at the time. So we still need to catch up on those IT security issues. We also need a case management system for our public defender's offices in order to be able to better keep track of all of the information in our cases, be able to access those things remotely when we're in the courthouse and when we're back at the office or out, doing work in the field with our investigators or what have you. And then also to be able to keep better data as a result of that system so that we can have better information for our future budget requests as well. That also eventually will include, as part of later phases, a electronic voucher system for our assigned counsel program so that we're not doing everything by paper because that's incredibly labor intensive, as you can imagine.
I wouldn't feel too bad about the IT issues. I think we all have that problem. Final one. The private attorneys, you said there were 350 around Kansas. Is that on average what it normally stays at?
Yeah, I mean, those lists are maintained by the district court, so they're always changing a little bit here and there. I mean, that's pretty average, though. And that obviously, there are a number of counties, as you can imagine, especially out west, where we don't have any public defender's offices, so their entire public defense delivery system is assigned counsel. But even in our larger communities, I mean, like, we regularly exhaust our assigned counsel panel here in Topeka, even though we have a public defender's office, we have a conflicts public defender's office, we have a contract counsel that takes cases as a backup to our public defender's office, and we still have a robust assigned counsel list here in Shawnee County, and we're constantly running into the, using that list a lot on cases because we're having to shut down our public defender's offices to new cases temporarily. Just to get back to answering your earlier question, I did misspeak. And for the phase 2 staffing, it was an additional 45 public defenders. So the final total after phase 3 would be a total of around 81 additional public defenders.
I've got you. I just want to give someone else a chance. Does anybody else have a question before I go back to Representative Delperdang? Yes, Representative Poskin.
So that study, and I will tell you right up front. I mean, one of the issues with that study, as far as we're concerned, is that the Bronx public defenders very much have like a sort of Rolls Royce of holistic defense models. I know like Kentucky and Texas definitely have probably more the Camry or Subaru version, but they still find that those are providing significant benefits to their cost effectiveness. The RAND study specifically looked over a 10-year period of time and compared the holistic defense practices in the Bronx Public Defenders and the Legal Aid Society of New York, and compared those with other public defense programs in that general area who weren't using holistic defense models. And what they were finding was that those, and I'll go back and make sure I've got those memorized here, because Of course, I don't have them all memorized right off the top of my head. But those figures were that they determined that they prevented over the 10-year period of time, they prevented more than 1 million days of incarceration. They reduced the likelihood of prison sentences by 16%. They reduced the actual prison sentence lengths by 24% and saved $160 million in taxpayer money, specifically in inmate housing costs as a result of that. And didn't have the recidivism rate that was any different than people who spent more longer periods of time and didn't receive holistic defense. So, I mean, that was a pretty significant study to kind of conclusively show that these, we all know from having done this work that anecdotally those sort of approaches work. But this was really the first widespread study that extensively studied this issue over a long period of time and showed those results. Traditionally, they have. Although, actually, so within the last, I want to say 5 years, maybe it's been longer than that now. I don't know, my age is showing. But the local law schools in Kansas, partially in result of the previous slowdown in the economy back in 2008, cut some of their law school admissions, and so they were graduating fewer students. And so there was a period of time where there just weren't as many graduates. It seems like now we're not having as much trouble finding graduates from our local law schools. I don't know if that's in part because they're having more of a focus on public advocacy kind of careers. But we've also started recruiting nationally as well and had some success with that. In fact, just within the last 2 months, we've hired from an Arkansas law school and from New Jersey. So I brought people from those areas to Kansas to work in public defender offices. These two were hired for our Wichita office because they were particularly low on attorneys. So I do think that one of the things that I have considered, and this is not something that we've officially decided as an agency, but I know that the Colorado public defender system, for instance, when you get hired there, they have right up front on their applications, they say, you're applying to work for our system and we will put you wherever we think you need to be. And because, as you can imagine, everyone who goes to Colorado wants to work in Denver or Boulder, not out in Grand Junction or, and so they, just made that as part of their hiring process that, you commit to this job and you're going to be put where we think you need to be. And I don't know if the details of that are such that they have an opportunity to move, but we certainly have tried to be pretty responsive when we have people who are already in our agency who are interested in transferring to another office to try to bend over backwards to make that happen in order to keep them. But that certainly could be a possibility in order to help us fill some of those role positions. Mm-hmm.
Other questions before I go back to Representative Delperdang? Okay, Representative Delperdang, go ahead.
Now I have two questions.
That's what we're here for.
First one is for my colleague to my right. Do you know what the surrounding states pay? Where you were roughly what, 80 an hour, give or take, or something like that? But
that are for our assigned counsel or for our public defenders? Our assigned counsel pay $80 an hour.
let's use that as an example. What would their counterparts be around in other surrounding states? Have you any idea?
I know, I don't actually have those figures off the top of my head, but I do know where I can get that information and follow up with you afterwards. As I recall, I believe Oklahoma, I think, was comparable. Obviously, Colorado and Missouri were paying slightly more than that, I believe. The real difference is the federal defenders, because the federal defenders are competing for attorneys in the same cities where we are, in Topeka and Kansas City and in Wichita, and they pay $140 an hour for their assigned
And
counsel.
second question, which is really my question. You mentioned earlier there was, and it's kind of a lead on from what he had talked about, there was 350 private attorneys on retainer, I'll call it due to lack of anything, but would you have any dollar amounts something you could throw at us or provide us that if you could hire full-timers here in place of using the outside help? Would it save money? Would it cost more?
Yes, actually, that information is contained in our budget request. So our average per cost of our assigned counsel is $995 per case for those assigned counsel. Our public defenders are $818 per case, and so it's typically more cost effective because you can hire more public defenders to handle essentially more cases, even if you're accounting for keeping track of those caseloads to make sure that those caseloads are not getting too far out of whack than what you're paying for the private counsel. And that's primarily because obviously when you're the $80 an hour that we're paying right now, or potentially $100 an hour if we get the budget addition that we asked for that part, it goes to cover overhead costs for each individual office. And there's, like I said, there's an economy of scale that comes with having the public defender's offices where you're not paying overhead costs for each individual attorney or to every 2 attorneys, because you've got this office as a whole and you're incorporating those as one overhead
Okay.
cost.
And you hit on my final part of that, because I was going to ask, is that the full burden cost or just based on an hourly? But I think it's the full burden. So thank you, Chair.
Other questions? I've got a couple that I just want everybody to understand the scope. One thing, Ms. Cessna, I would encourage you to do, I thought last year's presentation had a lot of comparative data. If you could update that data for us when you give your hearing. I know you have some severe issues, but the comparative data sometimes I think is going to work better for us than some of the aspirational things that we have. Do you remember, and you don't have to be exact on these numbers because I've got some ballpark numbers in the back of my mind and I haven't had a chance to work on them, but how much was the budget request that we passed out of the House approximately? We had about 600,000, I think, in here to address some of your needs last year. You had some caseload changes. Do you remember roughly what that number was?
Yeah, so last year, separate from our actual budget request that we had made a year ago this past September, our board, because of the severe issues that we were facing in Salina and Wichita and Topeka, had passed and asked for an additional $500,000 to address both some additional public defender positions in those specific areas, and then also additional staffing and some other related costs. I believe the actual cost that passed out of the House last year was only around $165,000.
I'm sorry, I'm talking about entire budget request.
The entire budget request.
Is it 40 million?
Our total budget is $35 million, or rough, give or take. I can provide those specific amounts to you out of our budget request.
We've got them, but I want the committee to understand some scope issues here. And then you guys got allotted approximately 3 million in the, wasn't there an allotment done last year by the governor as part of the cost cutting?
Allotment for, you mean for?
Reduction in your budget as we were dealing with the budget shortages?
Yeah, so for the fiscal year 2021, based on our caseload consensus conversation, and that's based on the reduction of the amount of cases that were coming through because of COVID specifically. Right. That was around, I think, 3.5 million. But I have to go back and look at that specifically. The governor did turn around in her most recent governor's budget recommendations and recommend an additional $4.1 million for fiscal year 2022, specifically to address our recruitment and retention issues and potentially help us with some additional positions.
And so what was that total, what was the governor's budget request for 2022, or your approved budget after it went through the governor's budgeting process for 2022, the one we're going to get the numbers on pretty soon?
Yeah, I mean, I know Martin's is actually listening to the thing right now, so he might jump in and correct me if I'm wrong, but it was around 37.5 million total, or 38. I'd have to go back and look at it specifically. Those are relatively new numbers that we just got.
On your request to the budget, to the governor's office, did you include the first year of this plan?
We did.
And what was that total request then?
That total request and enhancements was 16 million.
So your total requested budget was then 51 million?
Yes,
Okay.
roughly.
In phase two, so 51 million represents the cost of phase one, if I'm correct.
And I did title these as phases, not years. Because,
Yeah.
we knew that would
And-
probably be uphill.
What is the total estimated cost of phase two on,
Yeah.
in other words, it's 51 million plus, I don't remember what the number was, but
Yeah, so phase two was an additional 24 million, and then phase three was an
go
additional.
slow for me, so we would be at 75 million overall for phase two. And then phase three, we
And then
would
phase
be,
three was 34.6 million.
we would be at 110 million.
Right, and just to give you some ideas of scope here, even if we stayed at 26,000 cases, when you divide that by, what ultimately ends up being around 110 million, that still works out to approximately $4,000 or $4,227 per case. There are certainly attorneys that I know in Johnson County who, regularly charge $5,000 a case just for misdemeanor DUIs. And we're talking about $4,000 a case for essentially everything from low-level felonies up to capital murder cases. So this is still, even at the extreme of triple our budget, which, and I will say, our phase 2 and 3 are definitely prospective and subject to revision and change as we, get into this. Those are not things that we have included in our budget request and will not be included in our budget request until our board has a chance to review and determine whether or not that's something that we ultimately want to include when we get to that point. So those are still a little bit kind of up in the air as far as that's concerned. That was mostly to give you an idea as to where we were heading. But even at triple our budget, like I said, this would still be a significant cost savings compared to what private attorneys would be charging.
And so where will, if our total budget, including assigned counsel, is 37 million, but we're needing to budget 110 million, I'm trying to figure out where I get the cost savings.
Well, and that's the cost savings eventually, and this is what we get to, is that it's with the holistic defense model, it's a cost savings not just for our individual agency, it's also a cost savings for down the line with things like bed space and corrections, things like avoiding additional costs of retrials and things like that. And it's also that when we are able to offload some of those cases back from our assigned counsel back into our public defender's offices, there's cost savings there that ultimately we will see that will help offset some of that request. So, if we were looking at, for instance, bringing even just like going from 56% of our cases being offloaded to our assigned counsel back to 50%, that's around 1,600 cases that we would have to bring back into our public defense system. That ends up being around $1.6 million. That $1.6 million back in our public defense system pays for those cases plus an additional 400 more cases. So you'll see some offsetting of some of these costs in that respect. The only reason why this probably looks as bad as it does is in part because there is some delay between when you invest in the public defender system up front and when you turn around and see that come back out of the assigned counsel program. And the reason for that is because the cases that we're handling right now in our public defender system, we're paying for right now in our public defender system. Whereas we don't get the billings on our assigned counsel until after their case is completely done. So the cases that are currently in our budget for fiscal year 2021, 2022, are based on our assigned counsel for cases that were handed off to our assigned counsel program in 2019 or 2020 or even 2018. So the cases that are being offloaded right now, because our public defender's offices are not being able to stay open because they lack that sufficient staffing, we're going to keep seeing those increased costs with that assigned counsel probably for another several years because of that delay in how the billing works before you start to see that come back down again as part of this process. So there is this point at which you have to put money into the process up front before you eventually start to see those benefits come back down. And that's part of the way that the system works. There's no way to really avoid that.
And are there any studies, and it may be in your document, where there's any estimation on bed space savings or, I mean, we know it'll happen, I'm not arguing that, but is there any way to have any kind of realistic estimation? I mean, there's not only savings cost for the state when they don't go to prison, but also I would assume some of these people that are assigned to you, they're sitting in county jails, increasing the cost of the property taxes in our local counties. But is there any way to estimate that number?
I mean, I know that that was part of the thing that was looked at as part of the RAND study. Again, you know, that's based on their version of holistic defense, which is probably not necessarily what's going to happen exactly here. So I don't know how precisely comparable that is. But that is actually one of the reasons why one of the success metrics that we picked as part of what we intend to continue to report back to all of you are days saved. And basically what that is as we handle cases and we determine, you know, what the original account was and what the original sentence would be based on that person's criminal history, we want to start keeping track of then what the ultimate disposition of that case is and show the difference there so that because we can calculate then based on the number of days that have been saved from prison, what that average per day prison cost is to give you a better idea of what that starts to look like. That is not something we've traditionally done, but that is something we plan to do going forward.
Does your office handle any misdemeanors at all?
We don't handle misdemeanors that are exclusive misdemeanors. A lot of our felony cases get misdemeanors that are carried along with them, so we handle those misdemeanors in that context. But we don't handle any juvenile or misdemeanor cases.
So the numbers that are represented as far as the case averages are 100% felonies, or there's some misdemeanors in those average caseloads?
They would be all cases with primary counts being felonies. Mm-hmm.
Any other questions? Anyway, Ms. Cessna, thank you very much for the presentation. I would encourage you to get us some of that comparative data that we had last year. I found that very helpful, at least, as we try to make our decisions on this.
Yeah, I can definitely do that. And in fact, my plan was before it's time for our budget hearing is to submit actual written testimony like I did last year with some of that additional information in it for you.
And we've got some real analytical people in here, so, don't be afraid, send it to us a little bit early. Sometimes we get wrapped up and we can't get to it, but sometimes we can dig through it and be a little bit better prepared when you present. And I think Alexis may have a preliminary date for our hearing. I don't know if you've had an opportunity to share that yet, so. Okay. Anyway, thank you very much.
I appreciate the time, and certainly if there are any other questions, definitely let me know. We'll follow up on some of the ones that I wasn't specifically able to answer today. Thank you.
Also, Amy Decker with Legislative Research has popped on the WebEx to maybe answer some concerns about the committee report out sheet. Ms. Decker?
Thank you, Mr. Chairman. Can you hear me okay?
I can.
Thank you. And thank you for letting me pop on the WebEx. I understand there's some questions about the procedure we're using this year for the subcommittee report process. Definitely 2021 is a unique year. So we are definitely addressing items as they come up. I will note that KLRD structured this process based on what we've been using for several years now with interim committee reports regarding the email receipt and the decision to default to an acceptance if we don't hear back from members. So we are using established procedures that our office has been using for interim committee reports. Was there something else you would like me to address, Mr. Chairman?
Well, there's just some concern by some of the members that they would rather, and I'm trying to make sure that I get the opt-in and the opt-out correctly shared, but they're concerned that if they have a problem with the report out, that it goes through like they signed it rather than having to affirmatively say that they agree. I don't know how to resolve it 100% because I know it's not really an agreement with the outcome. It's an agreement that that's what happened in the meeting. But I don't know how we can allay any of their concerns.
Mr. Chairman, I believe some of the comments may have been about whether or not those reports would be received, if there were any technical issues. We would be happy to accommodate if you're would like to give us a personal email address. We'd be happy to send copies to both your house email address as well as your personal email to make sure that you do receipt those reports. And if by chance one doesn't reach you in the time that is stated, we can certainly submit that later to appropriations, even after the report out, that report that you did not agree that that report was ready to be read into appropriations. Certainly, we can make that, even if it's after the fact, we can certainly have that reflected in the appropriation minutes if you communicate that to the appropriate fiscal analyst.
Representative Pepperdine.
Thank you, Chairman. So I think I initiated the reply back, and I on purposely did a reply all. I do not normally do that. I do not like it now, and I understand the response on that. But by doing that, I'm hoping it did go under the Kansas Open Records Act. But I have a real problem with I'd like to know another document, a contract, an agreement, anything that you can give me for an example that if I refuse to sign it, it constitutes my agreement. And that's what I'm reading into this. And it's nothing pointed at your office, but rather I've had issues with on other budget committees where certain entities or agencies downright refuse to provide us the information, and our only comeback is to say, I refuse to sign your budget. And by what I read is my refusal is suddenly my approval, and no, that is not my agreement.
And I
Can I
certainly.
ask you a question, Amy? And maybe this might be a small solution to this issue. Can we, if a member requests it, can they just be put down as they don't agree unless they affirmatively get a hold of you? I mean, my understanding of the process is whether they sign it or not, I still do the report out. Is that something that maybe a member can note that they're not to be listed as they approved it unless they affirmatively get a hold of the appropriate person?
And Mr. Chairman, I just want to clarify that if the majority of your members do not agree that it's ready to move on, you would not present that to appropriations. So if you don't have the majority of your committee agreeing it's ready to move on, that would not be able to be presented to appropriations.
Gotcha.
And
Well,
I
I guess it's just going to be imperative for these two members to get a hold of you and tell you that they're okay being on that so that I can do the report out when I need to do the report out. And I can have them discuss this with you.
I would be happy
Privately
to discuss it offline, as well as make sure that all the fiscal analysts who staff public safety understand that those are of a concern and make sure that they are particularly attentive to those concerns.
You're right, correct. Thank you very much, Amy. Oh, I'm sorry, Representative Esau has a comment.
And it is mostly just a comment that my concern with what I was concerned about now that we're doing this, sorry about any feedback, that we are presuming that people have received it and that they're in agreement with it, is that so many of us are now a part of the process, whereas within our committees, it might have only been a dozen people, something like that. I have no idea why this mic feeds back. It did that the other day too. I'm too close to a speaker or something, so I'll have to like learn where to hold my head in the mic and not talk. Anyway, my concern was simply that we have so many people on budget committees now, and that if they miss an email or it gets lost in all the emails that we suddenly get flooded with occasionally, that they might have had a concern and they overlooked it and didn't catch it. Perhaps now that we're doing so many people, we need to reconsider some other way of people giving an affirmation versus a presumption.
I think you said it right, and I think that's the difficulty of this this entire thing. You know, I'm trying to think. I've had this committee for 2 years. I'm not sure that I've had anybody refuse to sign a committee report yet. But I mean, I do understand your concerns, and anyway, let's try to work it through with everybody. I know, like, for instance, sometimes we have extremely short deadlines, like we're going to see one next week. And I don't know who all I've had this conversation with, but we do have our report out deadlines. I have sent a copy of what our schedule looks like for February for both legislative research staff and the ranking minority member and the vice chair to look over to, one, try to catch my mistakes, because, you know, this process, for those of you that are new, is we have a hearing. As much as possible, especially on a detailed budget, I like to give you a day to think about it. So, like, for instance, if we did a hearing on Monday, we would work it on Wednesday. For legislative staff, they like to have 24 hours to get the document together that we need your approval on, and then I report it to the Appropriations Committee. So anyway, trying to hit all of those dates and backing them up is what we're trying to work on. You will find, by the way, when you get our report out, we have two of the smallest budgets in state government in our purview. One is the abstractor's budget, and another one that's relatively simple is a fee-funded professional. It's the trade professionals, just the engineers and things like that. You will find when we do that we're going to hear those one day and then work them the following day. One, it's so we can hit our deadlines, but usually they're very simple budgets. But anyway, we should be getting that to you guys so that you guys can kind of have a heads up of what the plan is, but I'm waiting to make sure I get some feedback from other members and staff. So anyway, representatives, if you have concerns of this nature, if you can get with Amy and we can see what we can do to make sure everything's copacetic. I wonder what copacetic actually means. Does anybody? Yeah, but it's good. It's all good. So is there any other business for the good of the order? Okay. If not, next week, you know, on Monday, we're going to have our first 3 budget hearings. I apologize already. Sometimes we're going to run past 5 because we got deadlines we got to hit. And are we running past 5 now? Just 10 till. Okay. Anyway, if there's nothing further, we're adjourned. Thank you.